Imagine a quiet chamber in Washington, D.C. Here, 9 individuals hold the ultimate authority to interpret the laws of the land. Their decisions reverberate across the nation, touching every aspect of American life, from individual freedoms to the balance of power within our government. This is the United States Supreme Court, an institution designed to be the highest court in the federal judiciary. It wields immense appellate jurisdiction over United States federal and state court cases involving constitutional or federal law. This powerful institution did not spring forth fully formed. It began with the Judiciary Act of 1789, establishing a Chief Justice and 5 Associate Justices. The court first met in New York City's Royal Exchange, then Philadelphia's City Hall. For years, it operated from within the United States Capitol building. It was not until 1935 that the Supreme Court gained its iconic, purpose-built home, a marble edifice signifying its growing stature. The Constitution itself doesn't explicitly mention judicial review, which is the power of courts to invalidate statutes or executive actions that violate the Constitution. Yet, this power is the very bedrock of the court's authority. Before the Constitution was even ratified, state courts were already asserting their ability to strike down laws that conflicted with their state constitutions, setting a crucial precedent. Debates among the Founding Fathers and influential writings like Alexander Hamilton's Federalist No. 78 clearly anticipated federal courts holding this power. They viewed it as essential to keep the legislative branch within its constitutional bounds. The defining moment arrived in 1803 with Marbury v. Madison. Chief Justice John Marshall, with characteristic strategic brilliance, used a seemingly minor case about a judicial appointment to assert the court's right to declare an act of Congress unconstitutional. Marshall famously declared, "It is emphatically the province and duty of the judicial department to say what the law is." This decision solidified judicial review, transforming the court from a nascent body into a co-equal branch of government. This was a pivotal check in the nation's system of government. From Marshall's assertion of federal power, through the divisive Dred Scott ruling under Chief Justice Taney, to the civil liberties expansions of the Warren Court in the mid-20th century, the Supreme Court has consistently evolved. The Roberts Court, sitting today, reflects a more conservative stance, impacting everything from voting rights to climate change regulations. Each era, defined by its Chief Justice, leaves an indelible mark on the nation's legal landscape, shaping how the Constitution is understood and applied. Today, the court consists of 9 justices, 1 Chief Justice and 8 Associate Justices. What sets them apart is their lifetime tenure, serving until death, retirement, resignation, or impeachment. This unique design aims to ensure judicial independence, insulating them from political pressures. When a seat opens, the president nominates a candidate, and the Senate provides its advice and consent. This process has become increasingly scrutinized and politically charged in modern times, often taking months. The confirmation process has become a highly visible spectacle, drawing intense media and advocacy group attention. Nominees face rigorous hearings before the Senate Judiciary Committee. While rejections are rare, the process can derail a nomination, as seen with Robert Bork in 1987. More recently, the political battle over Merrick Garland's nomination in 2016, followed by Neil Gorsuch's confirmation after a rule change to eliminate the filibuster for Supreme Court nominees, underscores the deepening partisan divide in judicial appointments. The Supreme Court receives roughly 7,000 petitions for review each year, but it grants only about 80. The justices decide which cases to hear using the rule of 4, meaning at least 4 of the 9 justices must agree to grant a writ of certiorari. This highly selective process prioritizes cases that resolve conflicts between lower federal courts or address significant questions of federal or constitutional law, ensuring the court focuses on issues with broad national impact. Once a case is selected, both sides present written briefs, followed by intense oral arguments, where justices actively question the advocates. After arguments, the justices meet in a private conference to discuss and vote. The Chief Justice, if in the majority, assigns the opinion writing. Otherwise, the most senior justice in the majority does so. Justices can write concurring opinions, agreeing with the outcome but for different reasons, or powerful dissents, publicly stating their disagreement. These published opinions become binding precedent, guiding lower courts and future legal interpretations. Despite its formidable power of judicial review, the Supreme Court operates under various constraints. It cannot directly enforce its rulings, relying instead on the other branches to comply. Its decisions can be overturned by constitutional amendment, rare but potent check, as seen with Dred Scott being nullified by the 13th and 14th Amendments. Congress can also, in theory, restrict the court's appellate jurisdiction. However, this is a politically fraught move, highlighting the dynamic tension within the branches of government. In recent years, the court faces mounting criticism regarding ethics and politicization. Public trust has declined significantly, dropping from the mid-60s in the late 1980s to around 40% today. Allegations of justices accepting substantial gifts, travel, and business deals without adequate disclosure or recusal have intensified scrutiny. The court recently issued its first-ever code of conduct, but critics argue it lacks external enforcement mechanisms, reinforcing the perception that the justices regulate themselves. Adding to transparency concerns is the increasing use of the shadow docket. This refers to the court's expedited decisions, often made without full oral arguments or detailed public reasoning. These decisions impact everything from execution stays to emergency injunctions. Critics worry this lack of transparency allows the court to make significant decisions outside the typical public scrutiny, undermining its legitimacy and making it harder for the public and legal scholars to understand how decisions are reached. The term judicial activism itself is a battleground, often hurled by those who disagree with a particular ruling, regardless of political leaning. Conservatives frequently cite Roe v. Wade as liberal judicial activism, arguing it created a right not explicitly in the Constitution. Conversely, liberals accuse the Dobbs v. Jackson decision, which overturned Roe, of conservative activism, arguing it disregarded nearly 50 years of precedent, known as stare decisis. This ongoing debate underscores the deep ideological divisions that now often mirror national political polarization. For decades, a crucial tenet of administrative law was Chevron deference. Established in the 1984 case, Chevron United States of America, Incorporated, versus Natural Resources Defense Council, Incorporated, this doctrine required courts to defer to federal agencies' interpretations of ambiguous laws, so long as the interpretation was reasonable. This gave agencies, like the EPA, significant power to implement regulations, shaping public policy in areas where Congress had not spoken with absolute clarity. It became one of the most cited cases in administrative law, a pillar of federal agency power. However, in June 2024, the Supreme Court delivered a monumental decision in Loper Bright Enterprises v. Raimondo, formally overturning Chevron deference. This move signals a significant shift, reducing the power of federal agencies to interpret broad congressional mandates. This decision builds on the major questions doctrine, first explicitly used in West Virginia versus the EPA in 2022, which allows courts to reject agency actions on issues of deep economic and political significance if Congress has not clearly authorized them. The overturning of Chevron marks a seismic shift in American jurisprudence. It reasserts the judiciary's role as the primary interpreter of law, potentially leading to more legal challenges against agency regulations, from environmental protections to healthcare rules. This move raises fundamental questions about who should ultimately decide complex policy issues: the politically accountable Congress, the expert administrative agencies, or the unelected federal courts. This will reshape the very contours of governance for years to come.